October 23, 1968, 9:17 a.m. Federal Courthouse, Foley Square, Manhattan. The doors closed with a dull thud that echoed longer than it should have. On the defendant's bench sat Ellsworth Bumpy Johnson, hands folded, back straight, eyes forward. No smile, no scowl. He wore a dark suit that had seen better days, but it fit him like intent. Across the aisle, 12 jurors stared at the floor. Behind them, reporters stopped writing. Because everyone in that room had just heard the same thing? Bumpy Johnson's own lawyer had handed the FBI a signed statement. Not a rumor, not a leak. A statement with dates, locations, and names. The prosecutor didn't dress it up. He didn't raise his voice. He simply said it. Your Honor, the defense counsel has provided federal investigators with corroborated testimony implicating the defendant in an ongoing criminal enterprise. The words landed. Heavy. Final. Bumpy turned his head slowly toward the man who was supposed to stand between him and a life sentence. The lawyer didn't look back. That was the incident. That was the betrayal. And everyone knew what it meant. If the statement stood, Bumpy Johnson was finished. The judge adjusted his glasses. Mr. Johnson, he said carefully, do you wish to respond before we proceed? The room held its breath. Because this wasn't just a legal problem, this was a survival problem. Bumpy Johnson had built his life on one rule: never speak to the government. Not through friends, not through family, and never, under any circumstances, through a lawyer. And yet here it was, typed. Signed, delivered. The FBI agents at the back of the courtroom didn't move. They didn't need to. This was cleaner than a wire, safer than a raid. The man paid to defend Bumpy had done the work for them. The prosecutor slid a copy of the statement onto the table. Pages rustled. The sound felt loud enough to crack marble. Bumpy's lawyer finally looked up. His face was pale, not guilty, not proud, afraid. That fear mattered, because lawyers don't betray men like Bumpy Johnson unless something is already wrong. Deeply wrong. The judge asked again, firmer this time. Mr. Johnson? Bumpy stood, not fast, not slow, controlled. He buttoned his jacket, looked at the jury, then at the judge. Finally at the man who had sold him out. I do, Bumpy said. His voice was calm, too calm. But not the way you think. A murmur rippled through the benches. The prosecutor frowned. This was not in the plan. Bumpy did not deny the statement existed. He did not accuse the FBI of coercion. He didn't even ask for a recess. Instead, he reached into his pocket and placed a folded document on the defense table. His lawyer's eyes widened. Before you accept anything from that statement, Bumpy said, I need this court to enter something else into the record. The judge hesitated. And what is that? A timeline, Bumpy replied. One that explains why my lawyer had no legal right to speak for me. The room shifted. Because now the question wasn't whether Bumpy Johnson had been betrayed. It was whether the betrayal itself was illegal, and whether Bumpy Johnson had known it was coming. The judge leaned forward, the prosecutor stiffened. The FBI agents exchanged a look they did not like. Because if Bumpy was right, then the man who sold him out was about to lose everything. And if Bumpy was wrong, he was about to lose his freedom. So why was he smiling? What did Bumpy Johnson know that no one else in that courtroom did? The lawyer's name was Walter Pierce, 46 years old, 2 kids. A wife who clipped grocery coupons and pretended not to notice the overdue notices taped inside the front door. Pierce wasn't famous. He wasn't rich. He was the kind of defense attorney who survived on small retainers and big promises, telling clients he could slow things down, while he prayed the calendar would save them. Taking Bumpy Johnson's case was supposed to be the thing that fixed everything. Pierce told himself it would be temporary. 1 case, 1 year. Enough money to clear the debts, keep his house, and finally move his family out of Harlem before the schools swallowed his son whole. That's what he told his wife the night he accepted the job. What he didn't tell her was that the FBI had already knocked on his office door. They came on a Tuesday morning, 2 agents, polite voices, clean suits. They didn't threaten him. They didn't need to. They laid photographs across his desk. Pierce walking into a bar with a known bookmaker. Pierce leaving a building under surveillance. Pierce shaking hands with someone who had died violently 6 months later. "You're not a criminal," one agent said, "but you're adjacent to enough of them that a jury might disagree." Pierce laughed then. Nervous, too loud. The agent slid one more photo forward. This one wasn't surveillance. It was his wife, standing at the stove, his daughter at the table. The address written neatly on the back. That was the first night Pierce didn't sleep. The pressure didn't stop. It layered. The mortgage notice, the call from his son's school, the phone that rang once and went dead. The sense, constant, unshakable, that he had stepped into something that was already closing around him. Bumpy Johnson never raised his voice, never threatened. He didn't have to. He spoke in facts. "You keep me alive in court," Bumpy told him during their first meeting, "and I keep your life simple." Pierce nodded. He believed him. But simplicity has a price. By the 3rd month, Pierce knew the government's case was tighter than advertised. Wire fragments, cooperating witnesses, a paper trail that didn't scream guilt, but whispered it often enough that a jury might lean in. Pierce asked for time. Bumpy gave it. Then the FBI came back. This time they didn't bring photos, they brought a deal. Sign a statement, limited scope, no testimony on the stand, no public cooperation, just enough confirmation to lock the timeline. In return, Pierce would walk away clean. No charges, no investigation. His family untouched. Pierce asked for 24 hours. He spent that night at his kitchen table, hands wrapped around a mug that had gone cold. His wife watched him from the doorway. "Is this man going to kill you?" she asked. Pierce didn't answer. He didn't need to, because the real fear wasn't that Bumpy Johnson would hurt him. It was that the government would. The next morning, Pierce signed. He told himself it was controlled. He told himself Bumpy would never know it came from him. He told himself the law allowed it. All lies. Because when Pierce handed over that statement, he didn't know one thing. Bumpy Johnson had already replaced him, quietly, legally, weeks earlier. Pierce walked into court that morning thinking he was managing damage. He didn't know he had just walked into a trap that had his name written on it. And as the judge leaned forward, eyes narrowing at the timeline Bumpy had submitted, Pierce finally understood the mistake he had made. He hadn't betrayed a client. He had testified against a man who had already planned for it. And now the court was about to ask the one question Pierce couldn't survive. Who was Walter Pierce actually representing when he signed that statement? The judge did not rule immediately. That delay mattered, because in the space between the statement and the response, everyone began to realize something was wrong. The prosecutor asked for a sidebar. The judge shook his head. Whatever this was, it was going to happen in the open. Bumpy remained standing, hands relaxed at his sides. He didn't look at Pierce anymore. That part was already finished. Instead, he spoke to the court. 2 months ago, Bumpy said, I terminated Mr. Pierce's authority to act on my behalf. Pierce's breath caught. The judge raised a hand. Mr. Johnson, do you have documentation to support that claim? Bumpy nodded and slid the folded document forward. A substitution of counsel. Filed, time-stamped, signed. The clerk read it silently, then passed it to the judge. Pierce leaned forward, shaking his head. Your Honor, this is procedural. I was never notified. That's not the standard, the judge replied. The standard is filing. The prosecutor shifted in his seat. This was not part of discovery. This was not part of strategy. This was a problem. Because if Pierce was no longer legally representing Bumpy when the statement was given, then the statement wasn't cooperation. It was unauthorized testimony, and that made it poisonous. Pierce's mind raced backward. The dates, the meetings, the night he signed. He remembered the FBI agent's smile, the casual way they said, we'll handle the rest. They hadn't lied. They had assumed Pierce still mattered. The judge looked directly at him. Mr. Pierce, when did you provide this statement to federal investigators? Pierce swallowed. October 20th. And when were you informed that you were no longer counsel of record? I wasn't, Pierce said quickly. I was still actively preparing the defense. Bumpy finally turned back toward him. That's not true, he said. Calm, flat. You were paid through September. A murmur spread. Bumpy continued. You didn't notice because you were distracted. I don't blame you for that. Fear has a way of narrowing attention. Pierce's face flushed. You set me up. No, Bumpy replied. I prepared. The difference hung in the air. The judge called for a recess. That was when the real danger began. In the hallway, FBI agents surrounded the prosecutor. Voices dropped. Hands gestured sharply. This was no longer about Bumpy Johnson. It was about exposure. Pierce stood alone near a water fountain, staring at nothing. His hands shook. He tried to steady them in his pockets, but the tremor followed. He understood now. The FBI deal had only worked if Pierce still had authority. Without that, he wasn't a cooperating witness. He was a civilian who had handed over privileged information. That carried consequences. The prosecutor approached him, voice low. Did you know you'd been replaced? Pierce shook his head. The prosecutor exhaled slowly. Then you may have a problem. Across the hall, Bumpy sat on a bench, speaking quietly to a man Pierce didn't recognize. Younger, calm, new counsel, prepared. Pierce thought of his wife, his kids, the photos on the desk, the promises made and already broken. He had chosen survival, but survival depended on timing, and his timing was off. The bailiff called them back into the courtroom. The judge returned, expression unreadable. Before we proceed, the judge said, this court needs to determine whether Mr. Pierce acted with knowledge of his removal. Pierce's heart pounded. Because if the court decided he knew, he was finished. And if the court decided he didn't, that meant someone else had played him. The judge looked at Bumpy Johnson. Mr. Johnson, he said, did you inform Mr. Pierce of his removal? Bumpy paused, just long enough. Then he answered, no, Your Honor. Pierce felt a brief, dangerous flash of relief, until Bumpy added, I wanted to see who he was loyal to when he thought no one was watching. The courtroom went silent. because now the question wasn't legal anymore, it was personal. And what Bumpy Johnson was about to reveal next would decide whether Walter Pierce walked out a free man or in handcuffs. The judge did not speak right away. He read the document again, slowly, once more from the top, then backward, as if hoping the order might change the meaning. It didn't. The substitution of counsel had been filed properly. The date was clean. The clerk's stamp was real. That part was settled. The only thing left was intent. The judge lifted his eyes. "Mr. Pierce," he said, "stand." Pierce rose on unsteady legs. "Did you believe on October 20th that you were authorized to speak to federal investigators on behalf of the defendant?" "Yes," Pierce said. His voice cracked. "Yes, I did." "Did you receive compensation for your services after September 30th? Pierce hesitated. Bumpy didn't look at him. He looked at the judge. "No," Pierce admitted. "But—" The judge raised a hand. "Answer only what is asked." Pierce swallowed. "No." The prosecutor shifted, uneasy now. This was slipping. "Mr. Pierce," the judge continued, "when you met with federal agents, did you disclose information obtained through prior privileged communications with the defendant?" Pierce closed his eyes. "Yes." The word echoed. That was it. The moment where everything tipped. The prosecutor stood. "Your Honor, the government acted in good faith." Mr. Pierce presented himself as counsel of record. The judge's response was immediate. Good faith does not sanitize illegally obtained information. He turned back to Pierce. "Mr. Pierce, were you offered anything in exchange for your statement?" Pierce looked toward the prosecution table, toward the men who had promised him safety. Then he looked at Bumpy Johnson, and in that look, something broke. "They said they'd leave my family alone," Pierce said. "They said I wouldn't be charged." A ripple ran through the courtroom. The judge leaned back, fingers steepled. So this statement was not voluntary testimony. It was an inducement. The prosecutor opened his mouth, then stopped. He knew better than to argue that point. Bumpy finally spoke again. "Your Honor," he said, "I move that the statement be suppressed in its entirety, and I further move that this court consider whether Mr. Pierce violated attorney-client privilege." Pierce's knees nearly gave out. This was the twist no one had planned for. The betrayal hadn't trapped Bumpy. It had exposed the government's desperation. The judge called another recess, short, sharp. When he returned, his voice carried weight. "The statement provided by Mr. Pierce is excluded," he said. "It will not be entered into evidence. Furthermore—" He paused. "This court refers Mr. Pierce to the bar for review of ethical violations." Pierce stared forward hollow. That alone would have ended him. But Bumpy wasn't finished. "Your Honor," he said, "there's one more matter." The judge sighed. "Go on." Bumpy nodded to his new attorney, who stood and produced a slim folder. "This court should be aware," the attorney said, "that Mr. Pierce's statement contained inaccuracies, not mistakes, fabrications." The prosecutor snapped upright. "Objection." "Overruled," the judge said. "Explain." The attorney opened the folder. "Mr. Pierce claimed my client was present at a meeting on August 12th. He was not. Mr. Johnson was incarcerated that day." A murmur. "And he claimed funds were transferred through a business that, according to federal tax records, did not exist until September." The prosecutor's face tightened. These weren't small errors. They were proof that the statement hadn't come from knowledge. It had come from pressure. Bumpy looked at Pierce now, not angry, not triumphant, disappointed. "You didn't just choose the government," Bumpy said quietly. "You guessed." Pierce tried to speak. No sound came out. The judge removed his glasses. "This court will not tolerate manufactured testimony," he said, "especially from an officer of the court." He turned to the prosecutor. "I suggest the government reassess how it conducts its investigations." The message was clear. Someone had crossed a line. But the real danger hadn't passed. Because outside that courtroom, word was already spreading. A lawyer had tried to sell his client and failed. Pierce was escorted out a side door, away from reporters, away from Bumpy, away from whatever protection he thought he'd bought. As he passed the threshold, one thought clawed through his mind. The government wouldn't protect him now, and the man he had betrayed never needed to touch him, because the damage was already done. And as the courtroom emptied, Bumpy Johnson sat back down, calm once more. The case wasn't over, but the illusion was. And the consequences of that exposure were about to land far beyond the courthouse walls. Walter Pierce did not go home that night. He sat in his office long after the sun dropped behind the buildings, the streetlight outside flickering like it couldn't decide whether to stay on. His nameplate was still on the door. For now, the phone didn't ring. That scared him more than if it had. By morning, the damage was public. The legal blogs didn't exist yet, but word moved faster than paper. Defense attorney referred for ethics review ran in small type on page 6 of the afternoon edition. His name wasn't famous enough for a headline. It was famous enough for isolation. Clients canceled. Colleagues stopped returning calls. The Bar Association letter arrived 3 days later, thin and final. Pierce read it twice, then folded it with care, as if neatness might still matter. The FBI never called again. They had gotten what they needed, or decided he was no longer worth the trouble. Either way, the protection he'd been promised dissolved without ceremony. At home, his wife watched him pack files into a cardboard box. "Is it over?" she asked. He wanted to say yes. Instead, he said, "It's quiet." That was worse. Across the city, the case against Ellsworth Bumpy Johnson limped forward without its centerpiece. Witnesses grew cautious, timelines blurred. The prosecutor requested continuances that suddenly came too often. The jury noticed. So did the judge. Bumpy was released on bond. Not victory, not freedom, but air. He stepped out into the cold October afternoon without comment. Cameras flashed. He didn't look at them, because the real cost had already been paid. Pierce lost his license within the year, not in disgrace, worse, in silence, no dramatic hearing, no defense mounted. Just a notice posted on a board no one checked anymore. His son transferred schools. His daughter stopped asking when things would go back to normal. Pierce took a job reviewing contracts for a real estate firm that never said his name out loud. He had survived. But survival came stripped. And Bumpy Johnson? He never acknowledged what had happened. No threats. No warnings. No messages sent. Which told Pierce everything he needed to know. The betrayal had been noted and forgiven, only in the sense that it no longer required attention. But forgiveness didn't mean forgetting. Because what Pierce lost wasn't just his career. It was the belief that choosing fear would keep him safe. And somewhere in Harlem, that lesson was already being absorbed. Because the street was about to respond in its own way. The reaction didn't come fast. It never did. For 2 days, Harlem stayed quiet. Too quiet. No speeches, no warnings, no sudden violence that outsiders expected when something big cracked. Instead, men talked in doorways. In barbershops, the radios stayed low. Newspapers were folded and unfolded, not read so much as scanned for names. People didn't argue about what had happened. They compared details. A lawyer had crossed a line. The government had overreached. And the courtroom had blinked. That mattered. Because for years, the unspoken rule had been simple. If the government wanted you badly enough, they would find someone close and squeeze until something broke. A cousin, a driver, a bookkeeper, now a lawyer. And this time it hadn't worked. That didn't make anyone feel safe. It made them careful. Men who had been talking to agents quietly stopped returning calls. Meetings got shorter. Names got dropped from conversations mid-sentence. The assumption that everyone could be pressured cracked just enough to let doubt in. The FBI noticed. Informants stalled. Tips dried up. One agent complained that people suddenly remembered their rights. Another said nothing at all, which was worse. The courthouse rumor mill sharpened the story as it moved. By the time it reached the corners, it wasn't about law anymore. It was about judgment. The man on trial hadn't lashed out. He hadn't panicked. He hadn't begged. He had waited and let the system trip over its own shortcuts. That image stuck. Not admiration, something colder. Respect mixed with caution. But there was another reaction, quieter and harder to see. Lawyers stopped taking certain calls. Defense attorneys, who'd once flirted with federal favors, suddenly remembered ethics rules they hadn't cited in years. Nobody wanted to be the next example. Nobody wanted to find out how much protection a promise was really worth. And in one small office downtown, a former attorney sat at a borrowed desk, listening to the hum of fluorescent lights, realizing that the shockwave hadn't missed him. It had started with him. The case itself dragged on, thinner now, less confident. The prosecution still had pieces, but the shape was gone. Whatever chance they had to make it clean had been burned when they tried to make it easy. And the streets felt that shift, not as celebration, as recalibration. Because when a betrayal fails publicly, it teaches everyone watching one thing. Not every door opens the way you expect, and not every man reacts the way fear demands, which made one final outcome unavoidable. One no one in that courtroom could control. The case did not end with a verdict. That's what surprised people the most. Months later, the charges were narrowed, not dismissed, not proven, reduced to something smaller, duller, survivable. No dramatic acquittal, no cuffs snapped open in triumph, just a quiet procedural end that barely made the papers. But the damage had already chosen its target. It wasn't the man on trial. It was the idea that selling someone out guaranteed safety. Walter Pierce learned that last. Years after losing his license, he was asked, casually, by a young associate why he had left criminal defense. Pierce paused, then said something he'd never said before. "I thought the law would protect the choice I made." That was the cost. Because in the end, the courtroom didn't reward loyalty or betrayal. It punished impatience. It exposed shortcuts. And it left one man standing not because he was untouchable, but because he understood timing better than fear, understood him. The last image isn't of a judge or agents or a headline. It's of a briefcase sitting unopened on a desk. Inside it, papers that never mattered. Because the moment that decided everything had already passed. Quietly. If this story changed the way you see loyalty, pressure, or the price of choosing wrong, subscribe. There are more stories like this. And they don't end the way you think.